An Arkansas stepdad is accused of killing his 2-year-old stepson. Police say he continued to throw the 2-year-old into a pool to teach him how to swim. The toddler's mom was also charged with murder. I will tell you that this is a story that isn't easy to talk about, and I will warn you that the details of this story are horrific to say the least. It's a day that the stepdad and mom, both now facing murder charges, say was a day of swimming that went wrong. But what police say is it's abuse that ended in the death of a toddler. I want to show you Dakota Hays right here. He's the stepdad of the 2-year-old boy who died. The boy's mom, Annastacia Atkins, who is also charged with first-degree murder. You see her mugshot and then that boy. Here's his picture. According to the Daily Mail, his name, Daxton Bull, just 2 years old. Police were called to a home June 17th when the boy was found unconscious. Hays and Atkins told police that they had been swimming at the home all day, and then they took a break for dinner when Hays then took the toddler back out for a swim at night. Hays later came inside and told Atkins that something was wrong and the 2-year-old was unresponsive. Police said the boy's official cause of death was lack of oxygen to the brain, but officers also noted that there were visible signs of injuries and bruising to the boy's face. The toddler wasn't the only child at the home. 2 other children under the age of 7 were also at the scene, and according to police, those children told officers that Hays and Atkins would often hit them and that Hays was very rough with the young 2-year-old who died. Perhaps the most heartbreaking part of what police have said took place is that one of the other children in the home told officers that Hays threw the 2-year-old into the pool when the toddler did not want to swim, and it was the older child that went into the pool to bring the boy back. Both Atkins and Hays told officers what happened was a freak accident, but I want you to remember that officers stated that the children in the home told them that both Hays and Atkins were abusive, and officers saw bruising on the 2-year-old's face who died. Joining us now is former Philadelphia prosecutor and current professor of law at Temple University School of Law, Marian Bracha. Thank you for being with us. This is not an easy story to talk about. What stands out to you when you read the details of this case?
Well, first and foremost, I think what is most noteworthy is that the majority of the information regarding the abuse comes from one of the other children. So obviously this was something that was occurring in their presence. Perhaps it was something that was occurring to the other children as well. I think the defense is going to have a hard time arguing that this was accidental, that this was a swim lesson gone wrong, because you have at least one of the other children reporting that this defendant was oftentimes aggressive with the 2-year-old, with the child. The decedent had healing injuries that indicated that there was trauma inflicted over a period of time. So what stands out to me most is that I really think that if the defense intended to present an accident defense, that this was just a terrible, again, swim lesson gone wrong. I think with a lot of the other evidence that's available in this case, they're going to have a problem with that defense.
This incident, the swim lesson incident, happened in June of last year, 2024. These arrests just happening in the first couple weeks of 2025. What does that tell you about this investigation, that it took so much time to get to the point where these 2 people are now in custody?
Well, I applaud the efforts of the investigators, frankly. I think that the argument from the defense would have been that this was a rushed or botched investigation if the investigators hadn't taken the time they needed to investigate the cause of death, to investigate the circumstances that the children were living in, to investigate any other instances of abuse that may have happened over this child's life, over the decedent's life. So I don't think 6 or 7 months is an unreasonable amount of time for investigators to do the necessary interviews they need to do, collect medical records, collect perhaps social service records, wait for an official cause of death from the coroner or the medical examiner in that county, and then proceed with a charging decision from there. I would applaud their efforts to make sure that the investigation is comprehensive and thorough before rushing to any judgment.
The 2 defendants in this case, Hays and Atkins, the stepfather and then the mother of the young boy, that is their defense, that this was an accident, this was a swim lesson. gone wrong. In these cases of abuse, in your experience, how common is it that those who are accused of committing the abuse say, this was just an accident, this wasn't something that has been going on for a long time leading to this point?
Yeah, I think that is a common defense. I think there are probably common defenses along these same lines, that this was either an accident or this was permissible discipline that went too far or that went wrong. Or, quite frankly, in the cases of co-defendants where you have two parents or two caregivers, what we see a lot is the defendant starting to point fingers at each other and saying, I didn't have access to the child, or I wasn't supervising the child at that particular time. My partner was, or the other person was. And so the two defendants, in essence, start to blame each other, which is problematic, not only for the prosecution, unless there is a conspiracy charge there where they were working in concert, but it's frankly also problematic for the defense, because I believe that the mother of the child was charged with allowing the child abuse to happen, to be perpetrated against the 2-year-old. And if you are if a parent or a caregiver, or one who's responsible for the child's well-being and safety, is there and is present to witness abuse happening, or has knowledge that abuse is happening, then there is a responsibility on that caregiver's part to remove the child from the dangerous situation, to seek help, to seek services, to report the abuse. And obviously, none of that happened if this abuse was ongoing before the child's eventual death.
I want to dive into her charges because, from what we've seen from police, Hayes was the stepfather, the person who takes this toddler out for this swim lesson at night and then comes back in and says, "Hey, something is wrong." That was what they told police. But she's facing a murder charge as well. Why?
Well, she's facing a murder charge because, as I said, when two people are, I think the theory would be accomplice liability. I'm not sure if there is a conspiracy charge that's been attached to either of the criminal complaints. A conspiracy charge would mean that the two defendants had to have had an agreement beforehand to engage in some substantial step to end this child's life. I think that in all likelihood there would be difficulty proving that there was a meeting of the minds and an agreement beforehand. But under a theory of accomplice liability, that aiding, that assistance in perpetrating a crime can come at any point in the perpetration. It can even come after the fact. So I think perhaps what weighed on the charging decision making was the fact that this couple, I believe, waited several days before they sought medical treatment for the child. They noticed something was wrong after this very bizarre nighttime swim lesson, and then it was several days before they actually took him to the hospital because he was unresponsive.
In your experience, when you look at these cases of abuse and you have this moment, and the headline of the story is, this is a swim lesson, the stepfather abusing the child through the swim lesson is what he's accused of doing. But police say that there were these injuries that appear were built up over time. How common in cases of abuse is it not just that moment where unfortunately a child loses their life, but there was something going on long before police were ever called to this house?
Yeah, Chris, unfortunately, that is very common. We know from our DOJ definition of domestic abuse, child abuse, intimate partner violence, that it is seldom a one-time incident. That abuse like this, household abuse, is a cycle of power and control. And so this child, unfortunately, was likely exposed to physical, if not more than just physical abuse, over a period of time, and that is common. That is very common in these cases. What is also not uncommon is that service providers like DHS, like social workers, like the court system, or police investigators are not aware that abuse like this is happening. And so there is no intervention, and there are no supervisory steps. There are no services put in place to ensure the safety of the child. So this, unfortunately, is something that happens behind closed doors in secrecy, and the people who suffer most are the children who don't have a voice and don't have an advocate.
There are just so many like heartbreaking details as you just go through what police say they found in this case, and the two other children who live in the home who provided a lot of the evidence that police kind of understood what was going on in this house, both under the age of 7. What likely happens to them now, knowing that their mother and their stepfather have been charged with murder?
Well, I would hope that they are safely placed, that they are with new and certainly better caregivers. I don't know if there is a foster situation in place or if there were other family members who were able to take custody of them. But I think what's important to note is if this case proceeds to trial, meaning that the defendants are exercising their absolute constitutional right to have all of the charges proved against them beyond a reasonable doubt, that the testimony of at least one of these children is going to be necessary. You have an eyewitness account from at least the 6-year-old to say what abuse the 2-year-old had been suffering, to say how many times the 2-year-old, had been thrown into the pool, that she actually had to swim down to the bottom of the pool to bring him back up, to help him resurface. So really what I think about in this case is how awful certainly it was for the 2-year-old, but also how traumatic it's going to be for the 6-year-old, perhaps even the 4-year-old, if he's deemed competent to
Hmm.
testify, to have to recount and relive the horrible things that they witnessed, that they also lived through, and have to share that in a courtroom full of strangers, onlookers, witnesses, and have to face their parents, their caregivers, and tell the world the horrible things that they witnessed and endured. So this is just an all around incredibly traumatic and heartbreaking story.
I know you've covered a lot of cases of abuse, and then as a prosecutor, I mean, how do you prepare kids that young to testify about something so horrific in front of a group of strangers? Incredibly intimidating environment.
It is a very intimidating environment, and I think you have to be very conscious of the fine line that exists between over rehearsing, if you will, and getting a child comfortable with the physical environment where they're going to present that testimony. So you can certainly bring a child to the courtroom, let them see what the courtroom looks like, let them hear their voice from the witness stand so they get used to the acoustics, take them on a little tour and show them where I, as the prosecutor, am going to be sitting, where the judge is going to be sitting, where they're going to see their parents, where their parents are going to be sitting. So you certainly want to go through that choreography, if you will, to show them the physical environment, but there is always a risk of over interviewing or over preparing a child for testimony to the point where to a fact finder, to a jury, or to a judge who's sitting in judgment, perhaps it sounds rehearsed, it doesn't sound credible. And so it is a very tactful job that prosecutors have to play to put child testimony on the stand, on the record, and make it effective, make it credible, but at the same time, make sure that it is genuinely coming from the recall, from the memory of the child witness themselves.
And I know you practice law. You were a prosecutor in Pennsylvania. This was a case that took place in Arkansas. States are different when it comes to particular laws. But when you look at these cases of abuse, what could the legal system do better moving forward to protect children who are in these situations, especially in stories like this, where there is evidence that there was abuse going on for much more than just one day at the pool?
Yeah, I think that's a really hard question to answer, but I appreciate it. And you're right, it should be all of our responsibility to think about the ways that we can all do better and the ways that we can make lives better for children, especially children who are most at risk. I think it starts, and as I mentioned, it's very difficult. It would have been very difficult to observe, to investigate abuse to a 2-year-old, especially if he wasn't in outside childcare, if he was only staying at home, if he was with these two parents or caregivers 100% of the time. Oftentimes, when kids go to school or they go to daycare or they're engaged in other activities, if there are teachers, guidance counselors, social workers, school nurses who sense that there is something amiss at home, some form of abuse happening, those staffers, those workers, those educators are mandatory reporters. And so they can trigger some services to be put in place, some home checks, some welfare checks to just make sure that the children are being cared for, that they're safe, that there is nothing amiss. In a case of a 2-year-old who isn't engaged in any outside the home childcare or education, that's going to be very, very hard to identify. So perhaps with children who are a little older, like the 4-year-old and the 6-year-old, education in the schools, education in school activities to let them know if there's ever something amiss at home, something that makes you feel uncomfortable or unsafe, or just something that doesn't sit right with you. If you're listening to your gut instinct or that Jiminy Cricket who's on your shoulder, to tell a grown-up, tell someone who is in a position to help you or help keep you safe. As Mr. Rogers said, look for the helpers and hope that things can be put in place that would prevent a tragedy like this in the future.
And with both parents now behind bars, both facing significant bonds, $1 million and then $750,000 for Atkins, how do you see this case going forward, knowing that there does appear to be a lot of evidence where that defense of this was an accident, that may not really hold up with a jury when you look at the evidence that the prosecution is going to have?
Well, as I mentioned, I think that something you have to keep in mind is it would be difficult to prove this case without the testimony of one of the other surviving children. And so I would think that the defense is going to hedge their bets on the strength of, or the strength or the lack thereof of the testimony of one of the other children. Now, of course, the prosecution can proceed with the police investigation. They can proceed with the medical records, with the medical findings from an autopsy report. They can proceed certainly with the statements from both defendants saying how this injury happened, and argue to the jury that that doesn't have the ring of truth, that it's not a credible explanation for how these injuries happened. But I think, based on what we know about the case right now and the evidence that's been reported, that the most powerful testimony is from the 6-year-old child, who can tell the events of that day, how many times the 2-year-old was thrown into the pool, how many times she had to go and assist him. The very bizarre fact that the stepfather took him back out to the pool after many hours of this swim practice, this alleged swim lesson that happened during the day, and continued to throw him into the pool. All of that testimony will come, and if it's available, again, if she's deemed competent, would come from the 6-year-old. And so I think one of the strongest things that the defense has going for it is to challenge the competency of the 6-year-old witness. Unfortunately, that is something that would be available.
Yeah, it's a tough job. Certainly a tough situation for that criminal defense attorney, whoever they may be. In your experience, how have you seen criminal defense attorneys walk what I assume is a pretty fine line when you're dealing with a child in a courtroom?
Well, let me put it this way. I have an equal amount of respect for our criminal defense bar, because as we know, our system of justice guarantees a criminal defendant the presumption of innocence unless and until proven guilty on all elements of all crimes charged beyond a reasonable doubt. And so it is the responsibility of the prosecutor to prove this case to that standard, and it is the responsibility of the defense attorney to hold the prosecutor to that standard. That's not to say that it's not an incredibly hard job strategically, legally, perhaps even emotionally and intellectually, for the criminal defense attorney to approach very graphic facts like this, and a fact pattern that is not going, perhaps is likely not going to sit well with a jury panel, especially if you have parents or caregivers on the jury panel. And at the same time, if there is a child called to testify, if the 6-year-old or even the 4-year-old are called to testify, there still needs to be an effective cross-examination to expose any weaknesses or inconsistencies in the testimony, or any lapses of competence, any inability to relate or recall the events of the day that led to the child's death. So in order to be an effective advocate, in order to provide effective representation for the defendant, that cross-examination still needs to be very effective. But at the same time, it needs to be executed in a way that doesn't alienate the jury or alienate the fact finder, and have them hold it against the defense, so to speak, for coming on too strong or too hard on a child witness. It is a very difficult task, and it's a very fine line to walk. You're right.
Yeah, very, very difficult job. Just a horrific story with the details that have come out thus far. Marian Bracha, thanks for taking the time to be with us.
Thank you, Chris.
Hays and Atkins are both being held at the county jail. Hays is being held on a $1 million bond, and Atkins is being held on a $750,000 bond. Again, this is an incredibly difficult story to talk about. Let me know your thoughts in the comments section. For Law and Crime, I'm Chris Stewart. We'll see you next time.